Relevance. To be admissible, all evidence must first be relevant. Evidence is relevant if it has any tendency to make a fact of consequence, which is in dispute, more or less likely. FRE 403. Furthermore, the court has discretion to exclude evidence under CEC 352 if the unfair prejudice, confusion, or waste of time it would create substantially outweighs its probative value. Prop 8. In California, Prop 8 amended the California Constitution and makes all relevant evidence admissible in criminal cases. Prop 8 did not change, however, the rules of evidence relating to 1. The U.S. Constitution, 2. Hearsay, 3. Character evidence, 4. The secondary evidence rule, and 5. CEC 352. Authentication. Non-testimonial evidence must be authenticated. Authentication requires the evidence's proponent to adduce sufficient evidence for the trier of fact to conclude that the non-testimonial evidence is what it purports to be. Hearsay. Hearsay is an out-of-court statement offered for the truth of the matter asserted. Hearsay is inadmissible unless a hearsay exception applies. It does not matter whether a person is currently testifying at trial. What matters is whether the statement was made in or out of court. Thus, if a witness seeks to testify about something she said earlier, out of court, for the purposes of proving the truth of that statement, it is hearsay. Statement of a co-conspirator. Statements made by a co-conspirator in furtherance of the conspiracy, offered against the opposing party, are exceptions to hearsay. Hearsay. The proponent of the hearsay must show by a preponderance of the evidence that there was a conspiracy between the hearsay declarant and the opposing party, and that the statements offered were made in furtherance of that conspiracy. The hearsay itself can be used to show the conspiracy. FRE 403. All evidence is prejudicial to some degree, but just because evidence shows that a defendant is more likely to have committed the charged crime does not make it unfairly prejudicial. Character evidence. Character evidence is evidence of a person's character that is being used to show that the defendant acted in conformity with this character in the present case. If the conviction forgery is admitted for the purposes of showing that Des committed this crime because he acted in conformity with his criminal tendencies, then it is character evidence. In a criminal case, a prosecutor generally cannot introduce evidence of a defendant's character unless the defendant opens the door. California recognizes several exceptions: 1. In a sexual assault/child molestation case, 2. In a domestic violence case, 3. In an elder abuse case, and 4. Where the defendant has put on evidence of the victim's violent character, the prosecution can put on evidence of the defendant's violent character. Impeachment evidence. Impeachment by conviction is permissible under certain circumstances. First, a party may introduce evidence of a prior felony conviction for a crime of moral turpitude. Additionally, 43 under Prop 8, the prosecutor may also introduce evidence of a prior misdemeanor conviction for a crime of moral turpitude in a criminal case. Unlike under the federal rules of evidence, California does not impose a specific time limit for determining remoteness. Bad act. In addition, this was also proper impeachment via evidence of a prior bad act. In a criminal case, a prosecutor can ask a defendant if he previously committed a prior bad act in the past that reflected the defendant's moral turpitude, if the prosecutor has a good faith basis for doing so. Prop 8 also allows the prosecutor to admit extrinsic evidence of this prior bad act. FRE 403. The final gatekeeping question for the court was whether the unfair prejudice of this evidence substantially outweighed its probative value. Attorney-client privilege. Attorney-client privilege protects confidential discussions between a client and her attorney for the purposes of providing the client legal advice. If the privilege applies, absent waiver by the client, the attorney cannot reveal communications protected by this privilege. There are some exceptions to the privilege. 1. The client was using the attorney's services as part of criminal or fraudulent activity. 2. The client was in a joint representation with another client, and the two clients are now suing each other over the subject matter of the joint representation. 3. The client and attorney are involved in a malpractice suit against one another about the representation. And 4. The attorney reasonably believes that the client is going to commit a criminal act, resulting in death or serious bodily injury, and the attorney could not talk the client out of it, and told the client that she would reveal this privileged communication. Relevance. All evidence must be logically and legally relevant. Logical relevance means that the evidence tends to make a material fact more or less likely. FRE 403. Legal relevance refers to a judge's discretion to exclude evidence if its probative value substantially outweighed by the risk of unfair prejudice, confusion to the jury, or unreasonable delay. Personal knowledge. A witness must have personal knowledge regarding what the witness wishes to testify to. Hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. This applies even to the testifying witness's own statements if they were made out of court. If a statement offered by a witness is offered to prove something other than the truth of the matter asserted, it will be admitted as non-hearsay. Otherwise, if it is hearsay, it must fall within an exception to be admissible. Effect on the listener. Statements offered to show the effect on the listener are classified as non-hearsay under the FRE. Non-hearsay purpose notice and otherwise hearsay statement may qualify as non-hearsay if offered to show the effect on the listener or the declarant's state of mind. However, the defendant has a right to request a limiting instruction so that the jury does not use the statement to prove the truth of the matter asserted, i.e. inadmissible hearsay. Party admission. A statement by a party opponent is admissible as a hearsay exemption when offered against that party. Subsequent remedial measures. There is a public policy exclusion for evidence of subsequent remedial measures taken when offered to show fault. Expert witness testimony. In order to properly admit testimony as expert witness testimony, the following must be met. I. It must be helpful to the jury. 2. The expert must be qualified in the field. 3. The expert must have a proper factual basis. 4. And the expert must have used reliable methods and applied them reliably. Lay witness testimony. In order for a witness's testimony to qualify as lay witness opinion testimony, it must be I. Helpful to the jury, 2. Be reasonably ascertainable based on the perceptions of a layperson, and 3. Not based on any scientific fact or specialized knowledge. Battery. Battery is unlawful touching of the victim's person which results in harm or offense. Authentication. All evidence must be properly authenticated, meaning that there must be enough evidence to support a jury finding that the evidence is what the proponent says it is. Proposition 8. Proposition 8 is a preliminary matter. In California, Proposition 8 permits the admission of all relevant evidence in criminal cases, subject to certain exceptions. Hearsay rules and exceptions still apply, as do constitutional requirements. To be relevant, evidence must be 1. Factually relevant, or make a material element of the case more or less likely, and 2. Legally relevant, in that the probative value of a piece of evidence outweighs its prejudicial effect. Confrontation Clause. The Confrontation Clause is a federal constitutional requirement, which requires all criminal defendants the opportunity to confront witnesses against them. It applies only to the admission of testimonial evidence. Testimonial evidence is generally determined under the primary purpose test, in which a statement is adjudged testimonial if the primary purpose of the statement is to assist law enforcement or give testimony. 911 recordings are generally not considered testimonial. Hearsay within hearsay. Hearsay is an out-of-court statement offered for its truth. It is generally inadmissible, subject to certain exceptions. When an item of evidence presents two levels of hearsay, as is the case with a recording, both levels must be subject to an exception to be admissible. Spontaneous statement. In California, a spontaneous statement, under the FRE, an excited utterance, occurs when a speaker becomes frightened or excited by a startling event and speaks during or shortly after that event while still experiencing the excitement. This type of statement is admissible as an exception to the hearsay bar, regardless of whether or not a declarant is available. Statement of infliction of violence. The CEC recognizes an exception for a statement made by a declarant that describes, narrates, or makes understandable an infliction of physical violence, or a threat of physical violence. The statement must have been made at or near the time of the event, must be made under circumstances indicating trustworthiness, and must be in writing, recorded, or given to emergency personnel. The declarant, however, must also be unavailable at trial. Business record. Must be made in the regular course of business, must be made at or near the time of the matter described, must be made by a person with personal knowledge or transmitted by a person with a duty to transmit the information, and must be authenticated by a custodian or record. It must also be a regular practice of the business to make such records. Character evidence. Evidence of a person's character trait to prove that the defendant acted in conformity with that character on a given occasion, or that the person has a propensity to act in conformity, is referred to as character evidence. In a criminal case, evidence of a defendant's character is not admissible in a prosecution's case in chief. The defendant, however, may present evidence of the defendant's pertinent good character, which the prosecution may rebut. However, the CEC recognizes an exception for character evidence in cases of sexual assault, child molestation, elder abuse, and domestic violence. Mimic. Evidence of a defendant's past acts may also be independently admissible if not offered to prove character or propensity. Evidence of past acts, for example, are admissible to prove motive, identity, absence of mistake, and a common plan or scheme. Secondary evidence rule. California's secondary evidence rule, the FRE best evidence rule, requires that when a document is admitted to prove its contents, an original must be provided. This includes duplicates or written copies. Logical relevance. Evidence is logically relevant if it has any tendency to make a disputed fact more or less probable than it would be without the evidence. Legal relevance. Evidence must be both probative and material in order to be legally relevant. Relevant evidence may nonetheless be inadmissible if its probative value is substantially outweighed by a risk of unfair prejudice. Witness competence. A lay witness must have personal knowledge of a matter in order to testify about it. Authentication. Tangible evidence must be properly authenticated, either through personal knowledge, distinct characteristics, by showing chain of custody, or, in the event of a reproduction of a photo, knowledge of the person who took the photo. Best evidence rule. The best evidence rule applies when a witness is testifying about a document, or the document is at issue. It mandates that in those circumstances, the original document, or a properly authenticated duplicate be entered into evidence. Hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted, and is generally inadmissible unless it falls under an exemption, or an exception to hearsay. Statement for medical diagnosis/treatment. When a statement is made for medical diagnosis or treatment, it falls under an exception to the hearsay rule regardless of whether the declarant is available to testify. Statement of mental/physical condition. When a statement is made about a mental, physical, or emotional condition, it falls under an exception to the hearsay rule regardless of whether the declarant is available to testify. Business records. Business records fall under an exception to the hearsay rule regardless of whether the declarant is available to testify. The business records must be made in the regular course of business at or near the time of the event by a person who had knowledge of the event. It must also be a regularly conducted activity of the business to make such records. Prior inconsistent statement. A prior inconsistent statement is admissible as an exemption to hearsay. Vicarious admission. An employee's statement may be admissible in a case against the employer if the employee was acting within the scope of her duties. A vicarious admission is an exemption to the hearsay rule. Statement against interest. A statement against interest is admissible as an exception to the hearsay rule, only if the declarant is unavailable. A declarant may be unavailable for a number of reasons, including she is dead, missing, or refuses to testify. Present sense impression. A statement of present sense impression is admissible as an exception to the hearsay rule, regardless of whether the declarant is available. The statement must be made at or soon after the event that is described. Excited utterance. An excited utterance is admissible as an exception to the hearsay rule, regardless of whether the declarant is available. The declarant must make the statement while under the stress or excitement of the event. Excitement can be evidenced by shouting or other excited behavior. Offers to pay medical expenses. Offers to pay medical expenses are not admissible. Under the federal rules of evidence, statements that accompany offers to pay medical expenses are admissible. California Evidence Code and Truth in Evidence, Prop 8. The California Evidence Code, CEC, governs the admission of evidence in California state courts. A constitutional amendment called the Truth in Evidence Amendment, Prop 8, was passed in the 1980s. Prop 8 applies only in criminal cases. It provides that all relevant evidence in California is admissible notwithstanding CEC rules to the contrary. Prop 8 has a number of exclusions, however: 1. Hearsay rules; 2. The Confrontation Clause; 3. CEC 352, Balancing Test; 4. Privileges; 5. Character evidence; 6. The Secondary Evidence Rule. Logical relevance. In order for evidence to be admissible, it must be logically relevant. That means that it must have the tendency to make any fact of consequence to the dispute more or less probable than without the evidence. Under the CEC, the fact must also be in dispute. Legal relevance. In order for evidence to be admissible, it must also be legally relevant, as tested under CEC 352. In order to be legally relevant, the probative value of the evidence must not be substantially outweighed by undue prejudice, waste of time, or confusion. In addition, there must not be any policy exclusions that might apply to prevent introduction of the evidence, such as prior offers to settle, etc. Authentication. In order for relevant tangible evidence to be admissible, it must also be authenticated. The standard for testing this is whether it is sufficient to sustain a finding of authenticity. A number of different kinds of authentication evidence are permissible: 1. Personal knowledge; 2. Circumstantial evidence; 3. Expert testimony; 4. Admission, etc. Secondary Evidence Rule. When the contents of a writing are at the heart of the matter, the secondary evidence rule requires that either an original or duplicate of the document be introduced into evidence or testimony where the original is unavailable. In California, a duplicate can be 1. Photocopy; 2. Carbon copy; or 3. Handwritten copy, not true in FRE. Independent legal significance, verbal acts. Layered hearsay. Hearsay is an out-of-court statement offered for the truth of the matter asserted. It is generally inadmissible unless it falls within an exception. The FRE has both exemptions and exceptions, but the CEC only has exceptions. The email is layered hearsay, so both the email itself and the statement contained therein must fall admissible under an exception. Business record. A business record is 1. A recording of an event or condition; 2. Made by someone with personal knowledge; 3. Made at or near the time the event; 4. Kept in the ordinary course of business, /. Admission by party opponent. A statement being offered against a party is an admission by a party opponent. The statement need not have been against the party's interest at the time it was made to qualify. Competence. For a witness to be competent to testify, she must have personal knowledge, present recollection, the ability to communicate, and understand that she is under a legal duty to tell the truth. T. Hearsay conduct. Hearsay encompasses all assertive conduct, which is conduct that is intended to communicate something. Thus, unless it falls within a hearsay exception, this statement, which is being offered for the truth of the matter asserted, that she would not have walked away if she weren't guilty, is hearsay. Adoptive admission. A statement being offered against a party is an admission by a party opponent. The statement need not have been against the party's interest at the time it was made to qualify. Adoptive admissions occur where a party is accused or confronted, and we would expect them to deny a statement, but instead they remain silent, implicitly adopting the statement. Excited utterance. An excited utterance is a statement made relating to a startling event or condition made while under the stress or excitement of that event or condition. A declarant's availability is irrelevant. Declaration against interest. A declaration against interest is a statement made by an unavailable declarant that was against his interest at the time it was made, and that the declarant knew was against his interest at the time it was made. In California, it can be against a person's penal, financial, or social interest. A statement is against someone's social interest if it would subject them to hatred, ridicule, or disgust. Declarations against interest are only admissible where a declarant is unavailable. A declarant can be unavailable due to death, inability to secure their presence through reasonable process, total memory failure, privileges, or their refusal to testify out of fear and despite a court order. Present state of mind. A statement describing a person's present state of mind, usually statements like "I intend" or "I plan," are admissible as hearsay exceptions regardless of the declarant's availability. Logical relevance. In order to be logically relevant, the evidence must make a fact that is of consequence in determination of the action more or less probable than without the evidence. Legal relevance. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, waste of time, or confusion of the issues. Most evidence is prejudicial, but not unfairly so, since it does not tend to arouse the emotions or passions of the jury. Hearsay within hearsay. When there are multiple levels of hearsay, each independent level of hearsay must be satisfied either by an exception or exemption. Statement by party opponent. A statement that is made by a party opponent is admissible against that party when introduced by an opposing party. Further, within this exception, an employee's statement related to a matter of employment, while within the scope of employment, are exempt from the hearsay definition under this exemption. Similarly, the statements by spokespersons or agents for an individual can be admitted under this exemption. In sum, under the FRE, statements under this exemption are deemed non-hearsay and can be offered for the truth of the matter asserted. Present sense impression. A statement made while contemporaneously perceiving an event and describing that event may be admissible under the present sense impression exception. Impeachment, prior bad acts. A party is permitted to inquire in specific instances of uncharged prior bad acts if they are probative of truthfulness. It bears noting, however, that counsel is bound by the witness's answer and may not provide extrinsic evidence to prove up the prior bad act. Logical relevance. Evidence is logically relevant if it tends to prove any fact of consequence in the trial more or less probable. Legal relevance. If evidence is logically relevant, then, it also must be legally relevant. Legal relevance is determined by whether the evidence is more prejudicial than probative. This requires a balancing test. A court may also exclude evidence that is not legally relevant because it would waste time or confuse the jury. Hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. As a general rule, hearsay is inadmissible because the validity of out-of-court statements is questionable.